Good morning, everyone. Thank you so much for joining us for our September Clear Up the Chaos. I am thrilled to have y'all here with us and have Kevin Reynolds and Christine Beldner with Ironwood. Sorry, say that again. Did I say it incorrectly?
Nope, no. You're good.
With Ironwood Consulting. And we have a full agenda with some really hot topics that I know lots of you have questions on, and we encourage you to ask those questions throughout the presentation. As a friendly reminder, you can send those questions via the chat box, and I'm happy to relay those to them, or in between each section. If you would like to ask those questions yourself, feel free to do that as well. But with our full agenda, I'm going to go ahead and pass things off to Kevin and Christine, and we are going to start things off with, as an organization, should we mandate the COVID vaccine? And I know on September 9th, there was some new things that were released from the president, and so I know y'all have a lot to share with us regarding those particular items. So I'm going to pass things off to y'all. And if you would kindly go ahead and mute your computer, and I'm going to let them take over.
Good morning. Thanks, Elizabeth. Appreciate the invite.
Yes.
So last week on the 9th, President Biden came out with a very controversial executive order, and our phones and emails have been blowing up. So we did a little bit of a pivot on today's presentation, and we wanted to kind of walk through what this mandate means, navigate the things that we need to consider, and kind of what we need to be planning for before we actually see the written rule from OSHA. So we're going to kind of dive deeper into this. So first of all, we got to keep in mind, this is just an executive order for OSHA to write this new rule, this new regulation. So until we see what's in writing, and no one has, we're arguing about how many angels we can put on the head of a pin. We just don't know. When we do know, when this regulation is written, Elizabeth and Ironwood and NCW has already agreed that we're going to put together a clear presentation on what the mandate is, what the mandate isn't, and how best to protect employers. That's what we're here to do, is protect you guys. So on September 9th, President Biden basically issued the executive order having OSHA to write what's called an Emergency Temporary Standard, an ETS. And this ETS is intended for employers, private employers. He has a couple executive orders for federal employees also, but right now we're going to talk about private employers. So basically, for private employers of 100 employees or more, he's asked that an emergency temporary order be implemented and written by OSHA. And basically, what does that mean? So, basically, the pending ETS, however, will let private sector employees allow for workers that are unvaccinated to produce negative test results, but the mandate is the employers are going to have to mandate a vaccine, or employees are going to have to provide a negative test result on a weekly basis. Now, there's a lot of hairs we can split here on this. So the reality is, a lot of people don't even know what that is, what an ETS is, how OSHA is getting involved in this. So OSHA has the authority to issue emergency temporary standards only if it can show two key areas. The first, OSHA has to show that employees are exposed to grave danger from a hazard. Second, the ETS is necessary to protect the employees from that danger. So in the last 50 years, only 9 emergency orders have been written by OSHA. And the most recent one was actually written in June of this year for the healthcare industry. It was the first emergency order written by OSHA in 38 years. Of those 9 cases that have been written, 4 of them were actually vacated by the courts, and 1 was partially vacated by the courts. So not saying, it's been 38 years before we've really dug into this and OSHA doing this. So how the courts ruled 38, 40, 50 years ago is not necessarily going to be what we should be expecting today. So I would not necessarily hold out hope that the courts are going to fight this emergency order. To give you an idea, the emergency order that was just written the first time in 38 years, it was intended for just the healthcare industry, and the union sued, basically claiming that they wanted it to apply to all workers, and they were not successful. So OSHA will issue the compliance timeline. Basically, it will not begin until Department of Labor writes the ETS. Now, typically, an emergency temporary standard typically is written in 30 to 60 days. That's what in the past it has been. It took quite a few months for the one in June to actually go into place. Now, we were at an HR convention last week, and we were talking with attorneys that were on the phone with the Department of Labor's general solicitor general. And she is saying that this emergency order there could be written as soon as 2 to 3 weeks. Right now, it's kind of hard to say, is it 2 to 3 weeks? Is it going to be 3 to 6 months? We don't know, but it could be as early as 2 to 3 weeks, but definitely within probably the 2-month time frame that this emergency temporary order is going to be put out. So once the rule is issued, businesses are likely to have a period to comply with it. Could be anywhere 30, 50, 90 days to comply with it. We won't know that until we get the actual timeline from OSHA. But even if it is 90 days at the longest outset, that's a pretty tight timeline for businesses to navigate and get in compliance. So the ETS can remain in place. So the key with an electronic, emergency temporary standard is basically it's a standard that, because it's emergency basis, it is not a regulation that will last any longer than 6 months. Basically, OSHA has to put out this rule for general comment for all these companies around the country to try to interject and massage this regulation. They have 6 months to finalize this emergency temporary order standard to being a final standard. In our experience and what we've seen with these ETSs for the few that have been put in place, basically, if the court system doesn't shut this down, that whatever comes out as the emergency temporary standard will have very little changes that will go into place once the 6 months timeline comes into play. So basically, OSHA has 6 months to do this, where they have to replace it with a permanent OSHA standard, and then we'll go through the formal rulemaking process. The federal employee mandate does include limited exceptions for legally recognized reasons such as disability and religious objections. Not sure if they're going to do that under the OSHA mandate. From the executive order, it's what we're seeing that they're not going to be allowing for that, but we won't know that for sure. Companies that don't comply with the rule technically could be fined up to $14,000 per violation, they will call that a serious violation of putting employees in grave harm. Now, I know a lot of our clients are very vocal. Some are very anti-vaccination. What I would warn against is, what are you documenting in regards to your being anti-vaxxer? So if you as an employer, as a manager or an owner, are openly saying we're not going to comply with this regulation, and this regulation does come into place, what you've done is you've documented the reason for OSHA to go willful. And for OSHA to go willful, they have to show that the employer knowingly put the employee in harm's way. So if your social media, which OSHA will go through, or your website, or your job postings, or your job description say, we will not mandate a vaccine when this regulation goes into place, you are opening yourself up to a willful, knowingly putting an employee in harm's way. Now, I'm talking from OSHA's perspective, that's the direction that they easily could go down. So be mindful of how you're documenting your objection to this if the rule does go into place. So OSHA does have 21 states that are state OSHA states. They have 30 days to develop their specific emergency temporary order. If the state doesn't already have a standard that's at least as effective as a federal standard. Most won't. California may be the exception of that. So if you're in New Mexico, if you're in Wyoming, those are state OSHA states that are close enough that we may have some clients. But if you're one of the 21 states, we got to be mindful. You might have a little bit extra time to play with. Now on the federal workers and the contractors, I'm gonna let Christine. She's got a lot more experience on the federal side. I'm gonna let her jump in regards to what she's seeing on this mandate.
Alrighty, guys. So really, what we already know is that on the federal side, you know, if your funding comes from the federal government, the reality is the mandate already, in essence, is going to apply to you. And I came from the Department of Defense industry. And so if your money is in any way tied to the federal government, you can anticipate in short term that you're going to have to comply with a vaccine mandate. And you're going to, at any size, whether small, large, medium-sized business, you're going to be the first that's going to either comply or lose federal funding. State-wise, it's going to come down to whether or not your state is going to be one of the states challenging this temporary emergency order. So Kevin, I think one of the things that the attorney spoke to at the SHRM conference last week is that there was at least 12 states that were already prepared to fight this emergency.
Yes, so there are 12 states. The Solicitor General did speak to the fact that there are some vocal states. She didn't list, but she was pretty much talking about Texas and Florida. Having some very vocal governors that are suing, but there are over 12 states actively going to be suing on this order. Even though a lawsuit is pending, unless they get a temporary injunction, the OSHA standard is going to apply once it comes out until a ruling is made. So we'll be watching it closely, but that's definitely happening.
So federal workers under the temporary, under the emergency OSHA order will have 75 days to comply. And this is, again, federal workers, not necessarily contractors. The federal executive branch workers will have to be vaccinated. The understanding, though, is that this will be extended to contractors who do business with the federal government, but then you're going to have a period of time where those federal contractors will have to, those businesses will have to put all this in place as well. So federal workers who refuse to get vaccinated, the understanding and the anticipation is that they will first have the ability to receive counseling, and then if they still refuse, they can face termination if they persist in refusing. So it'll be interesting how this plays out, but ultimately, if you're tied, if your money, if in any way is tied to any kind of federal funding, you're going to be the first that will have to comply with federal vaccine mandate. And there's going to be absolutely no way that you can avoid that.
So when it comes to this mandate, some of the things that we want to consider when it comes to how this applies to you, or the slippery slope of typical when laws are put into place, something that may not apply to you now may apply to you tomorrow. Some of the things we want to consider, considerations are, requiring employee vaccinations may increase your liability. What we're finding is we've had this happen within our client base. When you start asking for or mandating the vaccine, employees may come forward with reasons that why they can't, medical reasons, disability reasons. So what you're doing is you're opening yourself up to potential discrimination issues because you're learning of medical conditions that otherwise you would not have known by asking for or telling an employee that they have to get a vaccine. The mandates do not negate the employer's responsibility to provide appropriate PPE. That is one thing that, OSHA is pretty strong about is even when they do mandate this vaccine, you can't just say, okay, I don't have to buy a bunch of masks anymore. OSHA still considers the mandate that even if you are fully vaccinated, if you're in high transmission areas or involved in dealing with the public or industries that deal with like healthcare industry, that they're still going to mandate the appropriate PPE be provided for safety precautions. Under ADA, American with Disabilities, companies may need to engage in an interactive process to assess reasonable accommodations and or religious considerations. I just saw a news posting this morning that a Navy football coach tried to use the religious considerations for avoiding the vaccine, and he was just terminated. He couldn't make that requirement. One thing that is not considered a religious accommodation is political and philosophical objections are not protected. So I know that's our one go-to with our employees and our clients, especially in Texas. You got to be very mindful of the vaccination records. That is confidential. You got to maintain those. You've got to address your storage, your retention requirements, additional burdens through technology. Or if you're communicating through email, how are you securing this data between managers? When you're asking for vaccination records, you're now creating a medical file. Under OSHA, when you're creating a medical file, you could, and you got to look into this, could and most likely are required to keep that medical file for 30 years post-employment. I find most employers aren't aware of the extensive medical retention guidelines that you have to have. If you have an employee that becomes positive for a work-related COVID exposure, and I say work-related because I'm splitting a big hair that's an hour-long presentation by itself, those documentations, those records, those medical records fall under that 30-year post-employment guidelines. Because vaccination records are confidential, and you got to just be mindful of that. So employers must develop a comprehensive vaccination policy. You need to address the administration, the application, what are you going to deal with, how are you going to apply this without discrimination, how are you going to deal with falsification of documentation. We see in the news where people are being arrested with hundreds and hundreds of vaccine cards. Those cards were printed by a sixth grader on cardboard stock. It's not real hard for anyone to duplicate that card. Curious how OSHA is going to come across and address that. Basically, because it's going to happen, we got to figure out how we're going to address that. Another issues that we need to look at is if you have an employee that just flat out refuses, how are you going to deal and navigate and walk through that process? Will that be an unemployment claim reason or a denial of unemployment? From what we're seeing, that most likely it'll be a denial of unemployment. But we won't know that until we get there. But you need to be looking at how you're going to be addressing this. And if you're going to develop a policy, and once you do develop a vaccination policy, you need to keep up and touch that policy every week or two, just to keep up with all of the changing regs and interpretation of those regulations. Highly encourage you communicate with Elizabeth, NCW, communicate with Ironwood, so you can stay abreast of these interpretations. The one thing that we can promise you from the Ironwood stance, and I know from NCW, we're here to protect you guys. So anything that we can do that is going to be a benefit of protecting you guys, we're going to be always finding that hair to split if it benefits us. Got to stay on top of the state legislation. Right now, the state of Texas prohibits businesses from requiring digital proof of vaccination. Now, that's not necessarily for employers, but it is for businesses that service retail public. So we got to stay on top of that. Basically, if your employee is going to be an anti-vaccination, you got to be mindful of this is not an employer marketplace. Basically, the employees can get a job without trying real hard. So losing good employees on this issue is something you're going to have to find out is what you're going to do. Are you okay losing some of your best employees with the vaccine comes into play, the vaccine mandate comes in place? Even if you're not 100 employees and you want to mandate the vaccine, are you willing to lose some employees? If you're not 100 employees, then you mandate the vaccine, but you got 2 employees, you got Jim Bob that's a worthless piece of junk that when he says, I refuse to get vaccinated, you're like, fine, you're fired. But then you have your longest term Sally Ray employee has been with you for 30 years and says, well, I refuse to be vaccinated. Now, are you developing a precedent that doesn't match? So you look at your policies, think about the unintended consequences of writing a policy and who that may capture. And if you need help understanding and vetting out those unintended consequences, we're happy to help you. Another thing to consider, we'll have to have it when OSHA OSHA permit at-home testing. I've actually had a number of clients come to me saying that we believe the employee, one, is falsifying an at-home test that they're negative, or even at-home test that they're positive because they're trying to go after the COVID PTO. Will OSHA mandate that it must be a medically provided test? We don't know that. That's something we have to iron out in your existing policies. If you're writing these policies, that's where we need to address, will at-home testing be permitted, or it must be done by a provider? Who's going to pay for those tests? Right now, and we're going to talk a little bit later, we're going to talk about the American Rescue Plan. Right now, the American Rescue Plan that went into place on March 31st, which allows for more reasons for employees to be paid and compensated, and the employers the option to voluntarily participate in this plan and get reimbursed for allowing employees off for COVID PTO, or allowing employees off to go get tested, or allowing employees off for side effects of the vaccine. Right now, that's an option for employers under 500. Well, that expires September 30th. So what does that mean? If your employer over 500, this reimbursement doesn't apply. So we need to find out, what's OSHA going to do? Is OSHA going to, in the government, going to say this is mandated payment that the employer has to do over 500, mandated for all employees over 100, or are they going to extend the American Rescue Plan past September 30th and then make it required again that employers pay for this? Lots of unknowns. So what we want to start planning. We want to encourage you, start encouraging all employees to get vaccinated if that's a requirement that's coming down or that's going to likely affect you, or if that's the stance the company wants to take. The reason why Ironwood does not feel that OSHA is going to lose this battle is the Solicitor General for the Department of Labor was telling all these attorneys we spoke with that they are getting the message that they are getting from their end is that these large employers are saying, thank you for being the bad guy, because we want to mandate this, but we don't want to be the one that mandates it. Now the government is mandating it, so you're now the bad guy. So because OSHA is getting a lot of encouragement or perceived encouragement from large employers, that's why we feel this mandate may definitely stick. Another thing, when it comes to planning, cover employers need to quickly ramp up your infrastructure in terms of your policies, your administration, your tracking. Who's going to be responsible for this? How are you going to maintain the confidentiality and such, as we talked about? Employers also need to decide whether they will mandate vaccination or allow weekly testing as an alternative. Which one are you going to do? Also, our employers will be required to provide paid time off for the vaccination to recover from the side effects. What if the American Rescue Plan doesn't provide that option of reimbursement? That's something that you guys are going to have to address. Business will also have to consider the costs associated with confirming negative test results. Is there going to be a requirement to confirm negative test results? Is it an option? We don't know. And while some insurance may cover the cost of tests, some states are requiring employers pay for that medical, considering that a medical test to be reimbursed to the employees. So if we have anybody outside of the Texas, Oklahoma, New Mexico area, get with us and let us know what state you're in, and we'll see if there's a requirement based on the state law. So we talked about a bunch of what ifs. I think I saw a question pop up briefly in the chat, but it popped off.
So yes, we've had several questions. So you addressed the cost, who's going to be paying for these tests. It sounds like that's still a bit of the unknown. It sounds as though within 15 days, some kind of announcement or decision is going to have to be made with the expiration happening on the 30th, correct?
So we're going to talk about the American Rescue Plan. A lot of people knew that the plan last year was a mandated requirement. Last year, you must, as an employer, provide up to 80 hours of PTO paid to an employee that was positive or quarantined or waiting for test results. That was for all employees that couldn't telework or were under 500 employees. That was a mandate. Well, all these small businesses got that money reimbursed back from the government off of their Social Security taxes. That expired December 31st, and from January 1st to March 31st, it became optional for employers to continue to follow that COVID PTO, those 80 hours. Well, the American Rescue Plan came into effect on March 31st, which then reopened the PTO paid 80 hours, gave more reasons why they qualify for that COVID PTO. That plan expires September 30th, but it did not mandate you pay for the COVID PTO. So we don't know. With the Delta variant running rapid, with this OSHA mandate, they all intermix. That I foresee they extending this September 30th deadline. What I don't know is they're going to switch back to the 2020 mandate that you must pay for it.
Okay, so another question I've received is, does a company currently have to pay an employee for taking time off to go get the vaccine?
It is an option under the American Rescue Plan, and we're going to go a little deeper in that a little bit later if we have time in this session. It is optional. Basically, if it applies to everyone under 500 employees that can't telecommute, but previous plan before March 31st did not have the vaccination, the time off for the side effects as a reason that they could be reimbursed. So as an employer, if you are following the old rule where we're going to pay for PTO for if you've got COVID positive or you're waiting for test results, now and you're going to continue doing that, which you probably should if you already were doing it for 2021, then you just get reimbursed by the government for paying those hours.
Okay, and then as far as documentation goes, for reimbursement, is there any current form or required report out there, or is it up to the employer?
Christine, can you speak to I think I saw that come across from Amanda. She lost power from a hurricane. We got a few employees down in the Houston area that were going to be part of this presentation. A hurricane knocked us offline. I believe, Christine, did you see that email about the 941 and the process of going through that reimbursement? Can you speak to that?
I can. I just want to clarify, though, I wasn't sure what kind of reimbursement. If it's talking about the COVID kind of PTO reimbursement, I can kind of talk through that. If it's talking about COVID testing reimbursement, that's too soon to know what's going to be involved with that. But sure. So COVID PTO reimbursement. So how that works is that if you have qualified leave wages within that quarterly period, depending on what kind of file you are, then when you file your 941, you would just reconcile that on your 941 tax report that you turn in. So typically, depending on your company size, if you do that in-house, your internal controller or CFO would need to work hand in hand with your HR staff to reconcile what happened in that quarter or that month, whatever kind of filer you are, to reconcile those numbers. If you have an external CPA, just make sure you get with them and let them know how much leave you had, COVID related leave you had in that period. So that way they can capture that when you guys file your 941 report for that previous period.
Okay, so
And
another, oh, sorry.
And there is an allowance that we've had a number of employers that may not, so you're getting reimbursed back the Social Security portion of your payroll tax, but that's not a large dollar compared to if you have 10, 15, 20 employees all of a sudden that go out on this COVID PTO. There is a provision for companies to fast track that money quicker than having to. We had last year, this was especially a problem. We had employees that had so many employees out that it could take them a year to get that dollar reimbursed. The government does have a fast track option in there.
Yep, that's the advance payment of credits, and that's Form 7200. So if anyone needs a link to those, just reach out to us and I can send you guys those forms.
Christine, if you'll send those directly to me, I can include those
Yep.
in follow up. That would be great. So another question. So as an employer, we're encouraging them not to ask their staff if they've been vaccinated, but we're kind of opening up another can of worms here, because if you have over 100, if you're not vaccinated, we're now telling them that they have to take a weekly COVID test. So then we are opening up another can of worms here, in that we now know that Bobby Sue hasn't been vaccinated. So how are we navigating that? Because Bobby Sue could say, you know what I'm saying?
So
Yep.
basically, or Christine, you want to take that?
Well, sure. I would say stay your course right now, but start preparing and planning, and start looking at, if you're one of these employers that are over 100 and going to be impacted, start planning on what your protocol is going to be when this OSHA order is going to be put in place, because you want to apply it consistently. You want to ensure that you're not being discriminatory in your application. And so doing something that is premature or without planning, without proper process and procedure, is going to lead to mistakes, and it's going to lead to potentially some discrimination that you don't want. And if you're not prepared and you don't have your proper protocols in place, then maybe you're not going to be set up to safeguard your employee information. Now's the time to do your homework. Now is the time to understand where you're going to store the files. What checklists do you need to have in place? Who's going to lock up these files? Where are these files going to be kept? What's going to be your facility of choice, let's say, if you're going to be the one sending the employee somewhere, things like that. So let's not start asking people for proof of vaccination yet. Now is the time to be meeting with your executive team, asking the tough questions. What's this going to look like? Who's the key stakeholders? Who's going to be responsible for what? Is our technology up to date? Do we want to store anything electronically? If so, what are the implications of that? Those are the kind of questions you need to be asking. Kevin?
And to expand on that, what if someone comes to you with a reason, a medical reason, a qualifying ADA reason why they can't take the test? How are you going to deal with and navigate the accommodations And that's where I think you need to lean on us and lean on NCW to help you navigate the accommodation requirements, understanding the accommodation requirements in the process, and or how do you navigate because everyone, if they're not going to claim ADA, they're going to go to on the religious considerations, and you just need some good guidance if you find yourself in that situation.
Okay, so a new question we've received: is there any indication that there might be an allowance for not requiring the vaccine if staff that have recently recovered from COVID and thus have antibodies?
I would like to say that's so, but I would find that highly unlikely. Because of the breakthroughs, because the push has always been, we're not going to rely on the antibodies as your form of defense, even though obviously there's some good sound medical reasoning behind that's just a sound protection. I want to say that I would be shocked. There's always a possibility. Like I said, we're talking about how many angels on the head of a pin right now,
Right.
but it'd be unlikely.
So I know, again, this is all just up in the air and these are all things that we're discussing, but it sounds as if this does move forward and is put into effect, that it's going to then be on the employer to keep track of all this information, and thus, per previous Clear Up the Chaoses, they're going to have to be in charge of this medical information for the 30 years per OSHA, correct?
Yes.
Okay.
30 years post-employment.
Okay.
So
Well, and I think
go
ahead, Kevin. I think that's a good point. If, if you're a company that's over 100, perhaps you have some internal safety staff, and you haven't been accustomed to working with them in an area like this, and it might be time to really come together, HR and safety, and really team approach this, because this is an area that they might be more comfortable in. Because one thing that we judge is this testing and this vaccine is OSHA going to take a PPE approach to this, and say that companies have to provide it as PPE. And so in that respect, then it's something your safety managers, if you guys are afforded, if you're a company of that size, is that something that they're going to manage? So there's a lot of intertwinement perhaps at companies of your size. Now, if you're a smaller company, then we know that many of people on this call are department of one, and you're doing everything, and so you're accustomed to managing everything, and it's even more important for you then to really dive into what does this mean on the safety side, and get really familiar in an area that you're probably not able to really dive into on a day-to-day basis, because you're probably more on the employee relations side. So now is the time to really start understanding how OSHA plays a more important role than ever before in your company. And I think that's really where we started this talk. And I really want to bring it back to that. The government exercising OSHA on this changed the game.
Yes,
Go ahead, Kevin.
And that's exactly where I was wanting to, a point we didn't bring up. It was a slippery slope from the federal mandate to 100 plus employees. If this gets tested and successfully wins in court, there's not a lot of reason that this mandate doesn't move down to 50 employees, 20 employees, all employees. This could easily be just the stepping stone toward that direction. So even though you're under 100 employees, I wouldn't necessarily say we're good, because this is, if they win this battle, it will likely, why wouldn't it move down to the smaller employers? And one thing we didn't touch on, as in regards to the reality here, there's only roughly 800 OSHA officers in the country. What's going to happen is they're going to get a tremendous amount of employee complaints. Basically, employees are going to say, my employer isn't mandating. So they're going to be inundated with those calls and complaints. They're not going to be sending companies out to, right now, there's over 100,000 employers that are over 100,000 private employers that have 100 or more employees and 800 officers. They're not going to be showing up your door tomorrow, but you're likely going to get a letter from OSHA saying, we've received a complaint that you're not vaccinating per the new regulation, and they're going to require you to have a written response back. Now, that written response is a hard document that you're legally bound by. Are you going to say, I'm not going to do it? Which then OSHA is going to say, we'll see you tomorrow. Or are you going to say, we are doing it? And then they get another complaint letter from your employees in a month saying they're not, we'll see you tomorrow. So now you have a document that you lied on that will put you in the willful area, talking about $136,000 fines, or you're going to submit a document saying we refuse to do it, and they show up, and now you have a document that says you're willful also. So be mindful that the letters are going to be coming. I don't expect a lot of on-sites initially.
And like Kevin and Christine have said, we are going to keep each of you abreast of all the changes that take place, anything that does go into effect. Please, know that we will do our best to communicate that to you. And if you do have questions as we continue to navigate this, feel free to reach out directly to myself and I can put you in contact with either of them. I think for time purposes, we'll go ahead and move on to, an employee's had COVID before and they come back to the employer saying they have COVID again. What are those steps? What does that look like? If someone's had it once and gets it again, can you get reimbursed for that employee having it twice? What does that look like? And what should an employer know?
So that's kind of, that comes off of the previous conversation. We talked about basically the Families First Coronavirus Response Act. That was originally the act that was passed back in April-ish, I think, of last year, where all employers under 500, if an employee was unable to telework, meaning work from home, or even if they were able to telework, but because they were so sick, they were not able to work that day or that half day or that hour, employees were entitled up to 80 hours of COVID PTO. And we talked about how you get reimbursed. The government 100% reimburses that. We already talked about that. They were entitled up to 80 hours of COVID PTO. I won't go into, there's a family medical leave component that they were entitled to possibly also. But for the COVID PTO, that was required until December 31st of last year. I find at least 50, 60% of my client base didn't even know they got reimbursed. You can still get reimbursed if you did not go back, if you paid for it back in 2020 and didn't do it. We still encourage you, go get reimbursed. So January 1st to March 31st, the option was there, not the requirement. As employer, you had the option to pay that 80 hours, not the requirement. Well, that expired March 31st, and then came the American Rescue Plan. Now, President Biden's American Rescue Plan also said this is not required, this is an option. So from April 1st to September 30th, employees are entitled up to 80 hours of COVID PTO. There's dollar limits. If you guys don't have the poster or never posted the poster, there's a Department of Labor poster that we can provide Elizabeth to share with you guys. But what the American Rescue Plan did was it took all the previous requirements and just added a few more. And the key here is after April 1st, if an employee already was reimbursed for 80 hours of PTO, now they get a second round. So what we found originally back in April and March of last year, there was a lot of fake COVID positives. Employees are like, woohoo, I get 80 hours to stay home. So they were faking positives. There was very little documentation required to prove that employee was positive. So then come October, December, when things really ramped up heavy, they became positive. They didn't get a second round. So, or when January, February, March hit, you didn't have to participate. Now they get that second round if you want to participate in the program. What we don't know, because this expires September 30th, is how's this mandate with OSHA going to come out? Is it going to, as we discussed earlier, Is it going to be a requirement to pay or not? Some of the things that, so kind of talk about some of the additional things. Technically, it's 80 hours of paid sick leave. Employers, if you're going to follow this plan until it's mandated, because right now optional, if you're going to follow this plan, employers can't dictate that they use their personal PTO first. The employee gets to choose. I want to use my COVID PTO versus my company paid PTO. This PTO doesn't carry over past September 30th. Any previous COVID PTO doesn't carry over. Basically, the reasons that they'd be eligible for this COVID PTO, it's for any employee from day one. So if you are, remember, this is optional plan. If you're going to participate from day one, an employee is entitled to COVID PTO. You got to think about it. The thought process is, do you want to encourage your employees to lie to you and say, I'm not sick because they need their paycheck? I can't go a week or 2 weeks, especially a new employee that have no earned PTO, or some small businesses provide no PTO or only provide a few days. Do you want your employees lying to you to come to work infecting others because they have to have that paycheck? So the idea, employee day one, if you're participating, can get the COVID PTO. So if they're unable to work, so the reasons that they could qualify, these are some of the reasons, and I'll tell you what's a little new this year versus last year. If you're unable to work because they are obtaining a COVID vaccine, or they're recovering from an illness, injury, or condition related to receiving the vaccine, that is new. That wasn't in the prior last year in the January through March requirement. So if an employee is going to get their vaccine, or they have symptoms now that require them to not be able to work from home or not be able to work, they're entitled to the COVID PTO up to 80 hours. Seeking or waiting for the results of a COVID diagnostic test because they have been exposed to COVID, or their employer requested a test, or they're experiencing symptoms of COVID. That's the same as it was last year. If you're waiting for a test result, you're waiting at home because your employer said you had to go home, if you're participating in the American Rescue Plan, that qualifies. If you're advised by a healthcare provider to self-quarantine, or a federal, state, or local government puts you into quarantine, flying to New York, you may be put into quarantine. You hear some of that that's going into place. Really, this is not different. This is the same as it was before. What we find is that's where one of the big abuses is an advisor of a healthcare provider advising. So last year, and right now with Delta really being at the high end, there's very few medical offices saying, after you go on Zoom with your doctor and every symptom in the world says, your employee has every symptom in the world, faking it or not, there's very few doctors that are going to say, come in to my office or go get tested. They may right then just say, we believe you have COVID, go ahead and stay at home. That's enough to meet this definition, not necessarily actually getting the test. There's no change there. Caring for an individual who is subject to a quarantine order, or a child that is out due to COVID. So we didn't talk about it, but there's a family medical leave component of COVID. It's called expanded FMLA. That only applies to employees that have been with the company for 30 days. And for companies under 50 employees, you have the option of opting out of providing that. Because this whole American Rescue Plan is optional, you can opt out completely anyways. But if you are participating in the COVID PTO, you have the option, if you're under 50 employees, to say, we're not going to comply with the expanded family medical leave. Where this one gets really iffy, and we're getting more questions on this, is schools are closing. So if a child, and child is defined as anywhere from even an adult child with special needs, if a child is unable to attend school, or their daycare or their child care provider is unable to take care of that child for COVID-related reasons, being closed for the summer is not one. But if they're closed or unable for COVID-related reasons, if the employer is participating in expanded family medical leave, that employee could get up to 12 weeks of paid time off. It's at 2/3 pay rate, not at 100% pay rate like we'll be talking about with the PTO, COVID PTO. But I won't spend too much time on that. If you have that scenario, please reach out. We can navigate that. Also, another reason, experiencing any other substantial similar conditions specified by Health and Human Services. Right now, that's off the table. That's for future pandemics. So changes to the Emergency Family Medical Leave Expansion Act, I kind of talked briefly about that. I don't want to take too much time on that. If it does apply to you, please reach out and we can go into that. Do you have any questions that come across on that
Can you
one?
speak to, is it up to the employer for them to determine where the testing takes place? Can an employee say, I took an at-home COVID test and it came back positive? I mean, is it up to the employer to regulate if they need to see actual proof? What does that look like?
So we just had this question. A employer felt the employee was lying, that they didn't even, they didn't tickle the brain deep enough, or that they were just lying on the fact that the test wasn't done and they said it was positive. We went through and dug through all the EEOC guidance, all the OSHA guidance, and we couldn't find anything that allowed the employer to mandate that a test be conducted by a medical professional. I guess, Christine, I'm gonna put you on the spot, is if our clients and NCW clients develop a policy dictating that test must be done and administered by a medical professional, can they do that, from your opinion? And two, if they do that, does that trigger the requirement to pay for it? Put you on the spot.
Yeah, I mean, I can't think of any reason I could see a claim for discrimination there, right? Because some employee could argue that I didn't have the financial means to pay for it versus another employee that would have the financial means to pay for it. So I would judge that you could have a discrimination claim there. So I would be careful with that.
Mandating a medical professional until we get guidance from EEOC on this one.
Right.
Just walk carefully.
Mm-hmm.
Is the best thing we say. Unfortunately, we can't give you better clarity.
Right. Some, what it comes down to is the opportunity some employees are afforded versus others. Some employees don't have adequate transportation, things like that. Oh, Elizabeth, you're muted.
Thank you.
And I saw something come
I just
across.
start talking. Okay, another question that's come in. If a clinic accepts Medicare, the mandate will probably apply to that clinic, even though they only have 21 staff members. Is that correct?
We did not discuss that. I need to dig that. That actually is what we've read, but we haven't dug deeper into it to confirm those details.
Yeah, I suspect that if
slippery slope.
Yeah, that if you have Medicare, the government's going to dictate that you're going to have to use that clinic, and that'll be mandated. You're not going to have any freedoms.
It's all about government dollars. They're going to use those government dollars to wield a heavy hand. And if you get them in some capacity, I know you guys, NCW has a lot of medical clientele. We fully expect that the mandate's going to follow that.
So I know there's 2 bullet points, actually 3. So the I-9 has been extended, and I feel confident that we can discuss that next month. As far as the sexual harassment amendment that took place September 1 and the compassionate use program, talking through the expanded use of medical marijuana, I may just have y'all send some information that y'all were going to talk about and send that in the follow-up, since there were so many great discussions about our first 2 bullet points. And then, of course, I just want to remind everyone, you know, as a client at NCW and Sanford and Tatum, you do have access to Ironwood, Kevin, and Christine at any point in time. You can reach out to me and I'm happy to put you in contact with them to continue seeking guidance, because I know this is ever changing. And I know, like Christine mentioned, a lot of you are one individual department and you can only do so much. And with things up in the air like they are, you know, we want to be that resource to you and help you navigate during these uncertain times. So I'm going to stop us there because I want to finish on time and I don't want us to run over. I know everyone's time is precious and you probably have something lined up next, but I will send follow-up email with some of the things, some of those forms we discussed, again, that Department of Labor poster, and we will go from there. But I so appreciate y'all's time, and please remember our October Clear Up the Chaos will be the second Tuesday. So if that's not on your calendar, please add it, because I know there'll be, I'm sure, new hot topics for us to discuss. So I appreciate y'all and I hope you'll have a great week. Thanks so much.
Thank you,
Bye,
guys.
guys.
Bye.